Hello, I am Wajahat Ahmed. The module is Torture, Constitutional and Legislative Provisions in India. The learning outcomes are to gain an insight into the comprehensive protection provided by the Constitution of India against torture, to understand various provisions in the procedural law and substantive law which deal with the prohibition against torture, to learn about the features of the Prevention of Torture Bill 2010. The rule of law means that no one shall be deprived of his liberty except in accordance with law, and all persons shall be equal before the law. It means that even the government and its agents have to act according to and within the limits of law. Custodial torture, inhuman treatment, handcuffing prisoners, third-degree methods which are often used and practiced by police officials during the course of their official duties are against the norms of civilized nations and are barbarous activities violative of the principles of rule of law and human dignity. The main objective of the police is to apprehend criminals, to protect law-abiding citizens, to prevent commission of crimes, and to maintain law and order. Instances of torture have been widely reported in the media. Torture is committed on a regular basis by law enforcement officials in the course of criminal investigations. In India, torture is not expressively prohibited by the Constitution, but the Indian law contains adequate provisions for safeguarding human rights, and sufficient safeguards against police brutality and torture also exists. Although the prohibition of torture in specific terms lacks constitutional authority, Indian courts have held that Article 21 of the Constitution implies protection against torture. Provisions under the Indian legal system. Protection against conviction or enhanced punishment under ex post facto law. Article 21 Constitution of India provides that no person shall be convicted of any offence except for violation of law in force at the time of commission of the act charged as an offence, nor be subjected to any greater penalty than which might have been inflicted under the law in force at the time of the commission of the offence. Protection against double jeopardy. Article 20, Clause 2 of the Constitution of India provides that no person shall be prosecuted and punished for the same offence more than once. Right not to be witness against himself. Article 20, Clause 3 of the Constitution of India provides that no person accused of any offence shall be compelled to be a witness against himself. Therefore, if there is any mode of pressure, subtle or crude, mental or physical, direct or indirect, but sufficiently substantial, applied by the policeman for obtaining information from an accused strongly suggestive of guilt, it becomes compelled testimony, violative of Article 20, Clause 3, Section 348 of Indian Penal Code. 1860 provides that whoso wrongfully confines any person for the purpose of extorting from the person confined or any person interested in the person any confession or any information which may lead to the detection of an offence or misconduct, etc., shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. The right against self-incrimination recognizes the fundamental principle of criminal law that the accused must be presumed innocent, and it is for the prosecution to establish his guilt. Section 24 of the Indian Evidence Act 1872 provides that a confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, or promise having reference to the charge against the accused person, proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supporting that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. Section 25, the Indian Evidence Act 1872 provides that no confession made to a police officer shall be proved as against a person accused of any offence. Section 26, the Indian Evidence Act 1872 provides that no confession made by any person whilst he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such persons. The rights against ex post facto law and self-incrimination are absolute and non-derogable even during emergency. Right to life and personal liberty. Article 21 of the Constitution of India provides that no person shall be deprived of life or personal liberty except according to procedure established by law. Article 21 does not contain any express provision against torture or custodial violence. The expression life or personal liberty occurring in the article has been interpreted to include constitutional guarantee against torture, assault or injury against a person. Right to be informed of the ground of arrest. Article 22, Clause 1 of the Constitution of India provides that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Section 49 of the Code of Criminal Procedure 1973 provides that the person arrested shall not be subjected to more restraint than is necessary to prevent his escape. Section 50 of the Code of Criminal Procedure 1973 provides that person arrested to be informed of grounds of arrest and of right to bail. The right of information of the grounds of arrest would enable the person arrested to prepare for his defense and also to move the court for bail or writ of habeas corpus. Failure of communication of the grounds of arrest would entitle the person arrested to release. Section 50A of the Code of Criminal Procedure 1973 provides that every police officer or other person making any arrest under this code shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his friends, relatives, or such persons as may be disclosed or nominated by the arrested person for the purpose of giving such information. Section 55A of the Code of Criminal Procedure 1973 provides that it shall be the duty of the person having the custody of an accused to take responsible care of the health and safety of the accused. Section 75 of the Code of Criminal Procedure 1973 provides that the police officer or the person executing a warrant of arrest shall notify the substance therefore of to the person to be arrested and if so required shall show him the warrant. Section 330 of the Indian Penal Code 1860 provides that whoever voluntarily causes hurt for the purpose of extorting from the sufferer or any person interested in the suffering any confession or any information lead to the detection of an offense or misconduct or for the purpose of constraining the sufferer or any person interested in the sufferer to restore or to cause the restoration of any property or valuable security or to satisfy any claim or demand or to give information which may lead to the restoration of any property or valuable security shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. In Meech Mohammed, the court held that the principal object of Section 330 is to prevent torture by the police. When a constable, during an inquiry into a theft case, violently beat the accused who died about 9 days afterwards from the effects of the beating, it was held that he was guilty under this section. In Shamkant v. State of Maharashtra, where the accused, the investigating officer and his assistant entertained suspicion about 2 persons in case of theft and subjected to detention of stolen properties, the accused were held guilty of offense under Section 330. Section 331 of the Indian Penal Code 1860 provides that whoever voluntarily causes grievous hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any confession or any information which may lead to the detection of an offense or misconduct or for the purpose of constraining the sufferer or any person interested in the sufferer to restore or to cause the restoration of any property or valuable security, or to satisfy any claim or demand or to give information which may lead to the restoration of any property or valuable security, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. In Munshi Singh Gautam v. State of MP, a person was taken to the police station and beaten, as a result of which he died. False statement by one of the accused police officials as to occurrence of death or disease deceased, believed by another accused that deceased came to police station in severe condition and after telling his name had collapsed. Accusations were found established against the accused, however, no grievous injuries were found on vital parts of the body of deceased. Therefore, conviction of accused under Section 304, Part 2 was proper. Provisions under the Indian legal system protect a woman from custodial torture. Section 376, Clause 2 of the Indian Penal Code 1860 provides that being a police officer commits rape within the limits of the police station to which such police officer is appointed, or in the premises of any station house, or on a woman in such police officer's custody, or in the custody of a police officer subordinate to such police officer, or being a public servant commits rape on a woman in such public servant's custody or in the custody of a public servant. Section 376C of the Indian Penal Code 1860 provides that whoever being in a position of authority or in a fiduciary relationship, public servant, superintendent or manager of jail, remand home or other place of custody established by or under any law for the time being in force, or a women's or children's institution on the management of a hospital, or being on the staff of a hospital, abuses such position or fiduciary relationship to induce or seduce any woman either in his custody or under his charge or present in the premises to have sexual intercourse with him, such sexual intercourse not amounting to the offense of rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. Section 46(1) of the Code of Criminal Procedure 1973 provide that where a woman is to be arrested unless the circumstances indicate to the contrary, her submission to custody on an oral intimation of arrest shall be presumed, and unless the circumstances otherwise require, or unless the police officer is a female, the police officer shall not touch the woman for making her arrest. Section 46(4) of the Code of Criminal Procedure 1973 provides that except in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offence is committed or the arrest is to be made. State-owned institutions typically include prisons and jails, but can also include nursing homes, hospitals, and institutions for the mentally ill. Custodial sexual assault can also occur outside of an institutional setting. United Nations Special Rapporteur on Violence Against Women has explained that when women or military personnel enter homes to search, question, intimidate, or harass, there is at the very least an unspoken presumption, if not an overt order, that those within the home cannot leave, thereby placing them in de facto, albeit in many cases unofficial, custody of the state. Such situations, particularly prevalent during breakdowns of rule of law, can be called constructive custody. Provision under the Police Act 1861. Section 29 of the Police Act provides that every police officer who shall be guilty of any violation of duty or willful breach or neglect of any rule or regulation of lawful order made by competent authority, or who shall withdraw from the duties of his house without permission or without having given previous notice for a period of 2 months, or who being absent on leave shall fail without reasonable cause to report himself for duty on the expiration of such leave, or who shall engage without authority in any employment other than his police duty, or who shall be guilty of cowardice, or who shall offer any unwarrantable personal violence to any person in his custody, shall be liable on conviction before a magistrate to a penalty not exceeding 3 months' pay, or to imprisonment with or without hard labor for a period not exceeding 3 months, or both. In the case of Dr. Mahmood Nair Azam versus State of Chhattisgarh and others, the appellant, while in custody, was compelled to hold a placard on which condemning language was written. He was photographed with the said placard, and photograph was made public. After referring to various provisions, the learned single judge called for a report from the Chief Secretary. The report was filed stating that the sub-inspector had been imposed punishment of censure by the Superintendent of Police. It It was also set forth that a charge sheet was served on all the erring officers and a departmental inquiry was held, and eventually they had been imposed major penalty of withholding of one annual increment, and a case had been registered under Section 29 of the Police Act against the erring officers. In the appeal division bench observed that on a reflection of the facts of the case, it is luculent that the appellant had undergone mental torture at the hands of insensitive police officials. Regard being had to the various aspects which we have analyzed and taken note of the totality of facts and circumstances, a sum of rupees 5 lakhs should be granted towards compensation to the appellant. The said amount shall be paid by the respondent state within a period of 6 weeks, and we realize from the erring officers in equal proportions from their salary as thought appropriate by the competent authority of the state. Prevention of Torture Bill 2010. The Prevention of Torture Bill 2010 was introduced in the Lok Sabha on 26 April 2010 to allow India to ratify the United Nations Convention Against Torture and other cruel, inhuman or degrading treatment or punishments passed by the Lok Sabha on 6 May 2010. However, in the Rajya Sabha, the government was forced to refer the bill to a Parliamentary Standing Committee. The Government of India stated that the laws being enacted to provide punishment for torture inflicted by public servants or any person inflicting torture with the consent or acquiescence of any public servant and matters connected therewith. The bill contains only 3 operative paragraphs related to definition of torture, 1, 2, punishment for torture, and 3, limitations for cognizance of offences. It lacks many of the key provisions of the United Nations Convention Against Torture. The 3 paragraphs outlined in the bill also fall short of obligations that the ratifying parties to the United Nations Convention Against Torture must undertake. Let's look at the definition of torture. The elements constituting torture in Section 3 and 4 of the bill are wholly inadequate. Not only they do not conform to the definition of torture established in Article 1 of the United Nations Convention Against Torture, but also hardly address the full scale of acts accounting to torture that are routinely practiced in India. Section 3 of the bill defines torture as whoever, being a public servant or being abetted by a public servant or with the consent or acquiescence of a public servant, intentionally does any act for the purpose to obtain from him or a third person such information or commission or confession which causes 1. Grievous hurt to any person, or 2. Danger to life, limb or health, whether mental or physical, of any person is said to inflict torture. Provided that nothing contained in this section shall apply to any pain, hurt or danger as aforementioned caused by any act which is inflicted in accordance with any procedure established by law or justified by law, the degree of harm required to constitute torture is more severe in the bill, whereas the convention's threshold starts from pain or suffering. The bill states that only actions that cause actual damage or danger constitute torture. The bill relies on the definition of grievous hurt found in the Indian Penal Code. All elements of this definition include physical harm that is visible upon and after its infliction. This is highly restrictive. For instance, act of beating the victim with a stick, inserting chili powder or petrol in the rectum, or electric current to the victim's body or private parts, hanging the victim upside down from the ceiling, waterboarding, illegal detention, etc., currently practiced by some security agencies around the world, would cause severe pain and suffering, but they may not amount to grievous hurt, danger to life, limb or death, even in its broadest sense. It has been held that a blow to the head with an iron rod in the absence of contrary evidence does not endanger life, and therefore is not grievous hurt. Being struck on the head with a shade and being hospitalized for 10 days thereafter too has not been held to be grievous hurt. Even stabbing the lower abdomen of a person leading to the protrusion of the intestines has not been held not to be grievous hurt. Gunshot injuries to the arms, thighs and back of a victim have in certain cases been held as not causing grievous hurt. Such acts which have conventionally evaded prosecution under the existing penal laws will continue to do so even more under the certain acts which are already considered as torture under Section 330 of the Indian Penal Code have been consciously evaded in the definition. Here, simple hurt by a public servant would call for a punishment of 7-year term and fine. The following examples of severe hurt for which a police officer would be punishable under IPC but not under the torture bill. Stubbing a cigarette on the body of a person several times. Second, whipping a person with various instruments. Number third, causing severe pain to a person that lasts for less than 20 days. Furthermore, the definition in the bill excludes purely mental torture, which is included within the United Nations Convention Against Torture. The Select Committee submitted its report on 6 December 2010 and recommended that the definition of torture should be suitably expanded so as to make it consistent with the UN Convention and include offences under the Indian Penal Code. Torture of women and children should be given special consideration, and attempted torture should also be made an offence. The definition of public servant should include government companies or institutions. Moreover, Section 4 of the bill infuses an additional and restrictive element into the definition of torture. Section 4 provides that the public servant referred to in Section 3 or any person abetted by or with the consent or acquiescence of such public servant tortures any person, A, for the purpose of extorting from him or from any other person interested in him any confession or any information which may lead to the detection of an offence or misconduct, B, on the ground of his religion, race, place of birth, residence, language, caste and community, or any other ground whosoever shall be punishable with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Thus, the bill is in contradiction to the formulation in the United Nations Convention Against Torture, which prohibits torture for any reason based on the discrimination of any kind, as an independent rather than an additional ingredient of torture. In effect, the bill would only punish those acts of torture which result in a very serious injury, were motivated by a desire to extract a confession or information. Summary. In this module, the comprehensive protection provided by the Constitution of India against torture has been discussed in detail. It entails an elaboration of the constitutional provisions which ensure the protection against torture. This module also discussed the various provisions in the procedural law and substantive law which deal with prohibition against torture. In the end of the module, the features of the Prevention of Torture Bill 2010 have been discussed in comparison to the UN Convention Against Torture. Thank you very much.